Yes.
May I be permitted to mention item number 70 and 71 of my lord? These are those tobacco notification virus where I challenge the virus of the notifications. So I was humbly praying, my lord, out of the two matters, at least item number 71 should be taken up on Monday at the top. So those are my factory operations are closed, my lord. So these notifications are coming into effect from first.
Very well, you bring your other side on Monday. Both of them are there.
Even just to Amit Sharma's taking notice, I also informed him. So can you keep it on the top?
It will be there where it is. You bring your other side, I'll take it.
Bye. Right, I'll serve this notice.
My lord, may I be permitted?
I'm grateful.
Yes.
My lord, may I be permitted to mention on item number, my lord, 819 of the last Friday's list. My lord, now it is not in the list. I have been informed by officer that somebody has mentioned for keeping it on next Friday. My lord, I am praying that my chance has come. 818 was taken, 1819 was of mine. My lord, my lord, without giving me the notice, I am the petitioner. My lord, I am humbly praying for that next Friday, let it be in the top, my lord, some priority may be given. Yes, my lord, just next matter was mine. I was there when the original site called. My turn came, and then my lord respondent made it adjourned. My lord, give some priority, my lord. Give some priority.
Even on that day, if he says that he's in personal difficulty, will you press?
No, my lord.
Then
some
that was what was
priority I am praying for.
That was what was no priority. Wherever it is, it will remain there. It is not that it will come at the top.
No, my lord,
it will be there wherever it is.
Chance came, and now, my lord, it is.
Chance came, it was not taken up.
No.
Then there was no chance. Yes.
My lords, may I be kindly be permitted to mention, my lords, for inclusion and upgradation, my lords. My lords, this is an extremely urgent matter, my lords. I have been served with a show cause notice, and post thereto, I have been continuously writing letters to the department to give me the seized documents, my lords. The case against me is denial of ITC. They have seized my ITC registers. They have seized my purchase invoices. I've been
upgradation. Please mention next week. I have not permitted anybody to mention for upgradation any matter. Mention next week, and please bring your slips. I'll not allow oral mentioning anymore because every day 10-15 minutes go. Give it. Let us see. 10-15 minutes are consumed in mentioning.
I understand, my lords. I understand.
Yes.
Much of.
Lordship, may I be permitted to mention a Group 6 hearing matter for inclusion in the list? Lordship, my only difficulty is the gratuity of the petition is being withheld without any quantification of loss. It's a writ petition of 2019, Your Lordship.
Give it.
Grateful, Lordship.
My lord, may I have your lordship kindly to mention for inclusion and upgradation? My lord, 140 notice has been issued on January.
Next week. Give your mentioning slips. I am not going to hear oral mentioning anymore.
Expired, my lord. On March 26th, the time will be.
Very well. Mark is still far.
Lordship, may I be permitted to mention a matter of 2020 hearing matter. It's a Hooghly Motors. I have claimed for ITC refund. Not the matter. There also direction for. Great.
Milord, may I only mention a matter?
By a coordinate bench for exchange of affidavits. 1 year has passed. Still, the respondents have not taken any steps. If your lordship would
give it. It will appear in the list.
May I have Milord's kind leave to mention a matter, Milord? This is a type 2024 only for inclusion in the list, nothing more, Milord. My learned junior is there, Milord. He'll hand over the slip only for inclusion, Milord.
Milord,
I'm very deeply obliged, Milord. Very deeply obliged.
Call.
Item number 1, permitted to mention one matter, my lord, hearing matter to include in the your lordship's list, my lord. This is
which year?
2019, my lord.
Give it.
My lord, I'm giving the slip.
One minute it was placed under heading dismissal.
Yes.
Due to our absence.
Yes, because twice.
Not dismissed.
Not yet.
My lord never passed a
place that it has not been.
Nah, my lord never passed
Nah,
an order on the
I-
first time. First time for not. This is for default is not. Anyhow, your lordships, can it be taken up any day subject to your lordships, my lord?
Today, if you are ready, I can take up, or if you want it some other day, I can take it some other.
Yes, my lord, if your lordships keep it in.
Very well.
Only one thing, Milord, the direction for filing affidavits. We have that of the state. Kindly clarify from my learned friends, senior friends, side, whether they will file the rejoinder or exception to that or not. If that is not,
It is required for clarification.
no, it is.
There is a direction. If I choose to file, file. If I
But
choose not to
otherwise,
file, not
on
to
the
file.
next day it will be Milord, again adjourned for filing or again service of court.
Not required at all.
Then no difficulty, we will proceed on the basis.
Exception you want to file, there was no direction for exception.
My lord, on the basis of the reports, it is covered very short, very short. Today I am not thoroughly prepared. That's why, my lord, I was seeking your lordship on Monday or Tuesday. Your lordship.
No, it will then appear. Monday, Tuesday will be difficult.
সেজন্য Monday, Tuesday বলছি। মানে for our personal reason, my lord, I will be for some time.
is contesting the bar council.
Oh. When will you be free from that?
After 6 months.
Now, if that 6 months.
After 6 months.
Election day. But Monday, if your lordship, I can finish it.
Monday, first day, it will be difficult. Tuesday, we can have.
Tuesday, your lordship.
Tuesday, কিছু আছে নাকি? Fixed আছে কিছু? Because group 4 matters,
Like a very short matter, my lord.
ফাঁকা আছে।
আমার তো বেরিয়ে যেতে হবে না। আমার বেরিয়ে যেতে হবে।
All right, তাহলে 2 PM রেখে দিই আর কি। হ্যাঁ? Tuesday 2 PM?
Yes, extended date.
লিখে নিন, order লিখে নিন একটা। Mr. Bari, learned advocate, appears for
Mr. Sanam.
লিখে নিন।
No, sir. 2 and 3
None appears for the petitioner.
for dismiss.
No accommodation is prayed for.
Well, appear for the petition.
Yes.
My lord, there was a direction, my lord, to add the NALSA, and the SALSA parties have done that. I've served up also upon them, my lord.
When did
By
you serve?
The deputy to service not already have the proof of service email.
When did you serve?
My lord, on 3rd
This
February,
is the third time it is appearing under the heading for dismissal.
my lord. On 3rd February, I have served. Thereafter, yesterday or again, I served. I have the proof of service.
Show me that you served on 3rd February.
Oh, sorry.
What is this? What kind of service is this? Email service, did I say?
Because
Find it very easy.
no, my lord.
Don't dodge the court like this.
Physical service, my lord, I have
It
not.
will, I will dismiss it for default now.
My lord, physical service, my lord, I will do that.
On 2 days, when it appeared as for dismissal, somebody appeared on virtual mode, sought to take time. Yesterday, after getting a beating from court, now you have appeared physically and you are handing up an email copy
My lord, I have
to
not.
show that you have complied with the orders of court.
I have
You
prepared.
did not add the respondents who I asked you to add, despite directions being there by
No,
court.
my lord, now
You
sir,
took 5 days, 7 days to add them. Only after the matter was first directed to be listed under the heading for dismissal when you did not appear. Then you appeared, sought for time. Thereafter, you added without writing when you added. Again, you did not appear. Again, the matter appeared under the heading for dismissal. Again, you sought for time. You did not file your affidavit of service. Today, again, it is appearing under the heading for dismissal. You don't have affidavit of service even today.
my lord, physical affidavit of service, I will bring, my lord.
What do you mean physical? This is no service at all.
I apologize, my lord. It's my fault, my lord.
If by Monday your service through speed post or registered post is not complete, I'll dismiss it.
My-
I'm telling you,
My lord, I'll serve it.
it will appear under the same heading.
I'll do that.
কোনো order pass হবে না. Don't play with the court like
My lord.
this. Merely because I'm lenient, don't think that you will get along with anything.
My lord,
I was also on that side, I know.
my lord, there were some miscommunications, my lord.
No miscommunication.
I will never
I'm
do that, my lord.
absolutely loud and clear. There was a direction for you to add NALSA. You have not added it. There was a direction on you to serve NALSA. You have not served it. Now you're coming and showing an email
My lord, no.
merely to show compliance because of yesterday's shouting. Unfair to court. Absolutely unfair. Now, henceforth, I will start dismissing matters on the first call only. Then you will understand. Since I'm giving you opportunity, you are taking it very leniently. And I would have not interfered. Since these are matters which are compensation matters, you are not going to suffer. The ultimate litigant will suffer. That is why I am not dismissing it. I would have dismissed it immediately on the very first day. If you take up these matters sincerely. Otherwise, don't take it. These are matters which should be looked up with all sincerity. These are compensation matters, acid attack and something, I'll simply dismiss it. That cannot be done. What kind of seriousness is this? Third, fourth time it is appearing like this.
I'm apologetic. My fault.
লিখে নিন একটা order record করুন. Your conduct should go. What is this matter is appearing under the heading for dismissal for the third time. Dispatch, it should be served.
My application was allowed. I filed contempt application. And contempt I filed an application for recalling.
My lord,
So there are two applications, one for recalling, one for contempt. I'll hear the recalling first then,
Yes, my lord.
because only if the recalling is sustained, contempt will go. If the recalling is dismissed, contempt will be taken.
So we are wasting any time, my lord. I take from the public, my lord. In the recalling application, there is huge delay, my lord. They have not, there is no explanation. You have to find a sort of objection to that.
And what is the ground for seeking recalling?
my
of
lord,
the-
the thing is
When
that,
was
my
the earlier order passed of which recall is
my
sought?
lord, in 2023. My lord,
2023 order.
February 2023.
And when is the recalling application filed?
My lord, one thing, my lord, we should, my lord, state before this court, my lord. After this order was passed, my lord, we have filed an appeal. The appeal was, my lord, time bar. My lord, that appeal, my lord, dismissed. The section 5 was dismissed, so the appeal was not heard on merit.
Malad, the only
Section
point.
5 dismiss means appeal dismiss. That is
Yes,
the
sir.
Pannalal Jaiswal,
Yes,
well
that has
settled.
been, that is dismissed. So, my lord, what we have tried to point out is that on that day, my lord, when the order was passed by the honorable court, my lord, the honorable court was not having the determination, my lord, to pass the order.
When
This
the
is-
order was passed, the court did not have determination.
No, that is, my lord, my point,
How do you show that?
my lord, from the list itself, my lord, which has been annexed
Yes.
to the, my lord, application. My lord will find from the list which I have annexed on that day,
Page 44, my lord.
page 44.
44
Page
and 46.
44.
The court has
The, my lord kindly sees the, what is the, my lord, determination on that day.
Yes.
My lord, the day is other, my lord, relating to library, Madhyamik Shiksha Kendra, and other education matters not assigned to any other branches under Group 2, including service and application connected thereto. So, my lord, library science, library services was included. My lord, this person, my lord, who is seeking the employment is not in library service. He is under the, my lord, service of a school as a librarian. So, my lord, this determination will, my lord, on that day is not lying with this court.
School as a librarian will not be included within library services.
No, library service is under
Means
mass
under the
education,
library of the
mass
government.
education department. That is, my lord, the public libraries, which are sponsored by the government. That is a separate, my lord, total separate institution. And
Will not relate to a library of an institution.
no, it is, my lord, it is a school library. Librarian of a school, my lord, the staff pattern of the school, my lord, there is, my lord, provision of a librarian, clerk, and other things, my lord. They are non-teaching staff of that school.
Yes, Mr. Barry.
My lord, first thing, my lord, this matter was heard twice in presence of them. Before disposing of this deed application, it was heard twice in presence of them. They never said or raised any objection. First. Secondly, my lord, kindly page 44 once.
44.
I am reading the determination. Matters, motions and hearing under Article 226 of the Constitution of India relating to library, Madhyamik Shiksha Kendra, and other educational matters not assigned to any other bench under Group 2, including service and application connected there. So kindly say other educational matters. And now the regular determination of education, page 46. Motions and hearing under Article 226 Constitution of India relating to secondary education under Group 2, including service and application connected there. So the school library was not specifically assigned. Only motions and other relating to educational service. So this will squarely cover the other educational matters. Library along with other educational matters. And his lordship had several matters regarding school education, library matters. Not only my matter.
No, but that will not give jurisdiction if jurisdiction was not there.
Yes,
Now-
that is not assigned to any other bench.
No, but if secondary education Group 2 including services, if this includes library, then this is assigned to this bench. That is one way of looking at it.
That is the
Yes.
thing.
It has to other educational
Not
matters.
assigned to any bench means
It means
that
that will
matter,
cover this other educational matters.
it may not mean also secondary education under Group 2 including services. If library services of a school are included in this, then this is assigned to this bench.
Other educational matters, the educational bench is.
Other educational matters not assigned to any bench. Now, if
Yes.
this is assigned to this bench,
Good.
it will not come to that bench. That is the meaning then.
Not library specific assignment of the
No,
library.
library, he says library means public library. If you treat it as a part of an institution, it will not come under library services. then in that case it is service of the school, where you may be a librarian, you may be a peon, you may be an accountant, you may be the headmaster, whatever you are. It is under the school services. Library means, say for example, National Library or any other public library sponsored by the government. In that case, the determination will be with this honorable judge. Otherwise,
Educational matter. Public library matters is not an educational matter.
that is why it is
That
said.
is why there is no.
That is why the differentiation is there.
Yes, the educational, which educational matter will go with this determination.
Given there, secondary education, all secondary education, the school is what?
Yes,
Secondary school.
The school is secondary school.
So
secondary,
educational matter, that-
no, secondary education matters is given at page 46, specially assigned.
In this, on page 44.
Page 44, it is not.
No,
Other educational,
which will include-
that is what I am telling. Other educational matters which are not specially assigned.
Yes.
This is specifically assigned. Secondary school education matters, including service, is specifically assigned at page 46.
But I will show that determination regarding school library, but especially assigned in other pages. But I will show, I annexing in my objection.
Very good.
There is specific
But-
assigned regarding
My lord,
school
because
library.
my lord, now it is within the jurisdiction of court number 18, my lord. This is the, my lord, determination. We are filing the matters before the that court, my lord, for this
Very well.
clerk and other
Leak it in.
services.
Can 1 of 2025 is an application Yes. But I appear on behalf of the petitioner. Now, before I proceed in the matter, that I should draw to my lord's kind attention
that found Miller that insofar as the matter is concerned, the father of the petitioner Miller, he was an assistant teacher, died on 17/5/2018, leaving behind wife and 2 children. At one point of time, an application for corporation appointment was made on 22/8/2018. 22/8/2018 for grant of compassionate appointment, and the managing committee of the school had taken a resolution on 22/8/2018 for grant of compassionate appointment. Then Millard, it appears that the matter went up for consideration before the district inspector of schools, and the district inspector of schools, Millard, on 31/12/2019 rejected the claim of the petition. He had referred to an order of 9th of July 2009, which I will be indicating. I have brought it for my lord's kind consideration. Now, Millard, your lordships may kindly consider that against Millard, it appears to Millard that on 31/12/2019, after this thing was considered, then Millard, another writ petition was filed, and on 27/7/2023, this order, Millard, which was passed on 31/12/2019, was set aside. Now, these are factual matrix which I must not say anything. Now, in the meantime, Millard, what happened, Millard, which I come to learn from my learned junior, Millard, that the mother died. And at one point of time also, Millard, the DI Millard passed an order holding, your lordship knows, Millard, that in compassionate appointment matter, and inquiry is made to ascertain what is the family income. Now it appears, Millard, that there was an observation that the family income of the particular mother, when she was surviving, that is more than the monthly income of a Group D employee. Therefore, Millard, it cannot be done. In no way, Millard, it can stand. Now, then, Millard, the mother died. The mother died. This Millard, my learned junior Millard, had affirmed a supplementary affidavit, and lordship may kindly consider this supplementary affidavit at page 9. He had died on 26/12/2023.
Page 9.
Yes, of the supplementary affidavit, date of death 26/12/2023.
Yes.
Now, Millard, I will be making a submission before my lord that at this stage, as an officer of the court, I can only say, Millard, that having regard to the fact of the subsequent events, because there are judgments which my lord is aware, and I have also brought a judgment of the Supreme Court, where my lord the courts have said that the court is bound to take into consideration the subsequent events. This is a judgment, my lord, reported in EIR 1985 Supreme Court 371, paragraph 10. My lord, I can hand up the judgment. 85 Supreme Court. Millard, just 1 second, Millard. Kindly take into consideration. 85 Supreme Court 371, paragraph 10. Paragraph 10 টা বের করে দে। 371 কোথায়? এটা তো 171।
Yes.
In the right hand side, Milord, because I find, Milord, that
Mr.
it has
Bhattacharya,
been,
problem
yes,
is, in compassionate appointments, the authorities are to act in accordance with the
With the
scheme
law.
or the rules.
yes.
Whatever the scheme is, whatever the rule is.
I'm
If there is
grateful to
no
my-
sufficient-
But Milord, equally, Milord, your lordship may kindly consider that this observation of the Supreme Court that the court is bound to take into consideration the subsequent events and mold the
That is if a
relief
proceeding
accordingly.
is pending. If
Yes,
the- if
yes,
during
yes,
pendency
yes,
of if there is no
yes.
proceeding pending.
No,
he
I say, Milord, the right of consideration of the claim of the particular petitioner. This is, Milord, initially it was done in terms of a particular recruitment rule, which my lords will kindly consider. This was done on the basis of a rule, my lord, that is, just 1 second, my lord. আমাকে একটু রুলটা বের করে দিতে পারলি না তো তুই তো জানিস না দাদা বই করছিস কোনটা আমাকে একটু বইটার থেকে বের করে দে রে বাবা Milord, permit me to place the judgment, the rules, because this is there. But Milord, the because there is, I require, Milord, kindly do not take the this, Milord, I do not get the proper assistance. That's why I said I am not in a position, because I should give it to the court, Milord, as and when the matter is required. Now, Milord, only thing which I say, Milord, having regard to the facts of the case, that I also found a judgment that which is AIR 2000 Supreme Court 1596, wherein the court is saying, their paragraph 1596, AIR 2000 Supreme Court 1596, paragraph 9, 13, 14 to 18. আমার সঙ্গে জানিস তো হয় না, আমার সঙ্গে খুব ডিফিকাল্ট, আমার সঙ্গে এই যে ঝিমিয়ে পড়ি, ওই জন্য আমার সঙ্গে কাজ করা খুব মুশকিল হয়। Just I'm handing over to my lord, the just kindly see this. Why I am placing this judgment? The reason is that the claim for compassionate appointment, it cannot be negative with or it cannot be rejected on the ground of Millard introduction of scheme or taking into account the income of the family. That my lord will be pleased to find in paragraph 9, 13, 14 to 18 this paragraph. ওইটা রুলটা বের করে দে আমাকে, এইখান থেকে বের করে দে। West Bengal School Service Commission selection of persons for appointment to the post of non-teaching staff rules. একটু এইটা কিনে এইটা আপনাদের একটু কষ্ট দিন। হ্যাঁ পেয়েছি, একটা পুরোনো বই এনেছি যেটা জীবনে কোনোদিন কাজে লাগে, এটা কোনোদিন পাবো না। কারণ হচ্ছে আমার মতো এটা সরিয়ে দেবো, ব্যাগে রাখছি।
Very well.
Now I have also got the particular rules which they have invoked. There is a green flag in the books, Milord. This is the rule. This is the rule, Milord, which is known as the West Bengal School Service Commission for selection of persons for appointment to the post of non-teaching staff rules 2009. আমাকে দিতে তোর এটা একটু এটা কোনটা? হ্যাঁ
Volvid cow, singular.
thanks. তারা একটু
Difficult.
Yes. Now, Millard, one thing, Millard, I should also show.
Which rule are you relying on, Mr. Bhattacharya? Because
Rule 20, and Millard, there is my one thing you. Millard, just 1 second, Millard, I might. Yes. Now, Millard, there is a schedule. There is a schedule in respect of compassionate, schedule 5. Schedule 5, therein the explanation cost to Millard, this is the Millard formula Millard they have adopted to arrive at a conclusion as to whether the family is in a distressed condition. Because my lords have laid down the law that compassionate appointment is an exception to the general rule of appointment, and it has to be seen at the time of death, whether the family is in penury or there is a distressed condition in the family. Now, Millard, how that thing has to be worked out, this has been Millard given Millard. But however, I say Millard that this cannot be, there cannot be a straitjacket formula. I say Millard that rules are, my lords have laid down the law that rules are handmade for justice.
but Mr. Bhattacharya, if the family has been able to survive for whatever reason,
Yes.
think this is a situation where there was a pensioner. Think of another situation where there was no pensioner, there was a person who was another earning member of the family, and for that reason, pension was compassionate appointment was refused. Some unfortunate incident happens, and the second breadwinner of the family also dies. Then will that be a ground?
Millard,
to
I
grant compassionate appointment?
as the example which was given by my lord, that one person is a recipient of a pension and another person is not a recipient of pension. There may not, the court will lean in favor of the person who is not a recipient of a pension.
No, that was not the question. Here in this case, there is a formula given on the basis
As to
of
how
you will arrive. Family pension is to be counted 40% of the family pension, and there is a formula given.
Yes.
That for a family of 5, this is the formula. For a family below 5, this is the formula.
Right.
Above 5 and below 5. So family pension is therefore one of the factors which is to be counted. Now, it is this factor which deprive the petitioner of being considered for compassionate appointment at the relevant point of time.
Right.
Now, even if family pension was not there, this family pension is just one of the factors.
Yes.
The factor which was to be considered in terms of the rule is what is the gross income of the family, and whether after the death of the breadwinner, the gross income of the family is up to such mark that they can sustain the penury, the condition of penury.
Yes.
It was found in his case because of pension. In some other person's case,
It
because
may
of somebody's salary, suppose it is found
Yes,
that
yes,
he is
yes,
above
yes,
that,
yes, yes,
and
I'm
that
bound to my-
person who is earning salary, he dies. Whether that can make him entitled to claim compassionate appointment, we'll have to look at it this way
Millard,
also,
I say,
because
Millard,
my hands are also equally tied.
of course,
I cannot go ahead and say that no, you
I-
give
I- I
compassionate
only say-
appointment.
I only say this much. I only say this much. Your lordship may kindly take into consideration that the subsequent event which had occurred and which my lord has given an illustrative example, because the mother is no more. If the mother is
I
no more,
understand, but the problem is
particular
that
family
we will have to tread our path in accordance with the rules. If the rules and scheme are
I say this thing, what is coming to my mind, subject to what calls for minor time consideration. That supposing Millard, if your lordship today direct the authority, whoever is the authority, to conduct an inquiry to see as to whether this person, because now there are
so
only
whether
two-
that is permissible after so many years down the line. When did the death happen? 2018.
Yes.
2018 death happened. We are 8 years down the line.
23 ডিসেম্বর 26 ডিসেম্বর
কবে?
2023 26 ডিসেম্বর
2023,
2023 26 ডিসেম্বর
December 23,
That is the second death of the mother. The original employee died in 2018.
2023.
Original employee in 2018.
17th May 2019. 17th May 2019, paragraph
2018, yes.
17 May 2018, there the father
So that's
died.
the material
Yes.
point of time because he was the employee.
Yes.
The mother was not the employee.
Now,
Mother's
this,
death is not going to have a bearing on compassionate appointments.
No, I do not say that. Yes,
So
yes, yes.
that is precisely the ground now. On that basis, whether I can direct the consideration of compassionate appointment, it
No,
will be an
I only say, Miller, this much. I can say this much that there can be, Miller, the court can go into the nature of the allegations made, or this, Miller, point was decided by our court. This point, Miller, was decided by our court that in exercise of the extraordinary jurisdiction, the court can prove into the fact and appropriate order can be passed for ends of
yeah, but
justice.
there has to be a law for that.
That is a
You cannot
judgment
take the
of.
employer to do something which the law does not.
No, I
permit.
say this. I can only make this submission that 91(1) CLJ, page 461, is a particular Miller judgment. This is a judgment of a learned single judge of this court. Miller, I can I am handing over to my Lord Miller my book. Kindly see paragraph 678. It can. The extraordinary jurisdiction, I do not say I have to be given appointment. This submission as an officer of the court, I will not make. But equally, I can say at least my financial condition, whether it can be considered by the authority at this stage, having regard to the fact that the recipient of the family pension had died.
Which paragraph?
Miller, I am referring to from the paragraph 678. It seems, Miller, that yes, these are all because Miller, I only say at this stage, Miller, I am not saying because Miller, even the order of rejection which they had passed against the petitioner, that there has been a natural death of this order because of the subsequent scenario. The order which was passed at that material point of time when the mother was the recipient of the family pension, there has been a natural Miller death of the person's Miller. Now it is for the court. If the court Miller bestows the milk of human kindness, then Miller it can be done. Otherwise, nothing. And extent of kindness to what extent? If you lordship ask me, that will be to the extent of making an inquiry, nothing more. If it comes to the minds of the authority, after Millard going into the
Difficult. Authority has already filed a report saying there is no provision under which I can do it. How will I do it? That is what the authority has said.
no, this portion Millard, this was in the previous order.
No.
Kindly say no after this.
There is a report of 20th of March 2024.
Yes.
Or
तो
rather,
मामा आएगा फिर
sorry. Yes.
ये तो लेके करना.
In this writ petition only. There is a
ये
two-page
तो लिखने
report.
पर भी थी. हाँ ये लिखे तो.
DI has filed a report.
My lord, DI filed a report subject to correction of my lord. This is filed on
I
your
have
20th of May.
20th March 2024.
Yes. 20th
Yes.
of March
It's a
2024.
two-page report.
Yes.
Paragraph 7.
The main ground they have taken is that there is no provision for reconsideration.
And for compassionate appointment, that is the ground. There has to be a provision. It has to be in terms of the scheme. If the scheme does not provide, that means it does not provide. There are several subsequent Supreme Court judgments after the 2000 judgment which is cited,
Yes.
which have said that that is what the law is.
That it has to be proceeded on the basis of the scheme prevailing.
Yes. If the scheme does not provide for it, it can't be done. Yes, sir. What is your
compassionate appointment through the you by the government for determining the family income, relying the rules of the there appointment for the petition the criteria are judged by the and already satisfied the family needs immediate assistance for the pain only distinct forwarded the name of the appointment.
आगे जो बोलते हैं.
Just to satisfy for issuance of the document. But as for my understanding, completely directed by
yes?
Yes. Take.
the rule does not. Now,
Yes, sir.
For the state, my lord, the report has lost my lord. Looked into the report, my lord, filed the report, and now it's up to your lordship, my lord, what is it?
Very well. I'll pass my orders. I'll consider it. Listen it. I'll keep it one more day. On that day, I'll deliver. I'll consider the judgments because since it has been cited, I have to deal with them. Heard Mr. Bhattacharya, Leonard Senior.
Grateful to your lordship.
Thank you.
On behalf of the petitioners.
Your Lordship, all.
Yes,
I served the copy of the
you are appearing for the state.
but the service is not affirmed, Lord.
He is appearing.
No.
How is it affirmed for us?
Yes, what has happened to his criminal case? So it is proceeded with.
I don't know, like, that's already submitted. সেটা খোঁজ নিয়েছি তো, খোঁজ নিয়েছি। খোঁজ নিবি তা নয়। খোঁজ নিয়েছি, কোথাও খবরই পাওয়া যায় না।
Charge sheet has been filed.
হ্যাঁ, হ্যাঁ,
I'm disposing this one.
yes.
Decaying.
same petitioner. I have in the later matter, the previous matter, Mr. Aduki is there, who is in petition number 5. Well,
The reports are ready. Why not?
my request of apology, my lord.
This is fourth time.
May I just say this? I had personally communicated with the personally. I explained that to you. I was.
Why is the report not coming? Whatever is
What
there.
What has come today is just that 10:52 a.m. this has come. It is not in the form of that, but this has come after everything has come. This is with regard to both the matters at the same time.
Let this come by way of a report and please ask the government leaders to come. Because this should not have happened.
Yes.
This should have come by way of a report and लिखे इनसे
Malad, I mean,
Take
light of the judgment, Malad, they ought to have, Malad, taken steps,
Exactly.
Malad.
And what about the second matter where no, this cannot be with regard to both of them.
Yes, Malad. In the
Because
second
in one of
matter,
the matters,
we have given reference.
they have not even been given the proper
Yes.
possession of the property at the threshold.
Possession of property has got to that was said in 825.
So this letter is nowhere.
May I indicate about this? If you not to take a look at it once again. But there is only a little I can say about these things, but subjects regarding I have also indicated that we can only address and lawyers not.
You please ask the learned government leader to come. I am passing it over, or I'll have to call them personally, and that will be very uneasy. I am passing it over. Please ask the learned government leader to come. Come back at no.
Lordship.
Wait.
Wait for me.
No, will kindly not take us and we are.
No, not at all. You all are officers of the court, but I have given them ample opportunity. It will be apparent from the order.
Then I will take them with the report. But
This will lead the court to presume something something very bad. This is something very bad. You are a state authority. Just imagine a bank puts up a property for sale. Somebody purchases it in auction. The auction sale is absolutely intact. It is not challenged. If I ask the bank to refund money, it will have to be refunded with interest. The property will have to be put up for sale again. Entire public money goes to stake again. What kind of service are these people discharging? It will be an ugly state of affairs, but I will have to do that. I will have to call them then. Because if they don't listen to court orders, there are several orders asking them to file report. They are not filing despite seeking time.
why they are stuck on the same thing that let this be tested by.
You have the earlier orders of court where the court has held that section 14. It's not.
By justice.
There are several.
Malad, there are several judgments, Malad, of the Madhya Pradesh High Court as well as of the Maharashtra High Court, Malad, your lordship.
Of our High Court also there are at least.
I have it.
And Malad, then your lordship.
Prior one is of Justice Sabyasachi Bhattacharya.
Yes, Malad, where your lordship has argued. State Bank matter. State Bank was take up this one.
But I will come back to those judgments.
Please bring those judgments also.
Lordship,
One I have only one by justice.
grateful.
Going to mouth.
Here.
Here, my another option number D was executed in between the sounds of the
Here,
order.
Who is appearing for the state?
I have some notice, my lord, on last occasion they appeared. Is Holo kache? Go time never.
You can take it on another day because
Who?
study is happening for responding about.
Who is appearing for the bank?
Bank my lord, on last occasion, last to directed me to serve a notice. I have served.
then another notice may be given, because in the absence of bank, this matter cannot be resolved, subject to correction, my lord.
Mr. Devashish Saha,
Yes, yes,
you have have his number.
my lord. On last notice, I served a written notice.
If you have his number, you can call him so that we can do it. I'm passing it over. If you can bring him, the matter can be done.
And that you'll also be prepared.
No, every matter can't be at 2 p.m. 2 p.m. I have other matters also. If you can bring him before 1:15, I'll be able to do it. Otherwise, it will be on the next day. Yes, next.
I'm for the petition in this matter, my lord. In terms of my lord's direction, I have served upon the private respondents as well as the state respondent. Private respondents have been delivered, my lord. And the learned advocate appearing for the state, my lord, has also been served, my lord. Mr. Devjit Mukherjee is appearing for the state respondent.
Why is nobody there? None of the respondents are here. Contact Mr. Devjit Mukherjee, see if you can call him.
Very good.
Because ex party, there's no use.
Yes, yes.
Passing it over again.
Very good.
Dean.
Mr. Mukherjee's junior is
Yes, very.
दादाजी আসবে very good.
Yes. What is your grievance?
Lord, my grievance is, my lord, I have an agricultural plot of land, my lord, which is situated nearby a river, my lord, that namely Mongol River. Now, my lord, the private respondent, my lord, in order to divert flow of the saline water, my lord, has, my lord, cut the embankment of the river, which has resulted in flowing of saline water into the nearby agricultural plots of land, including my land. But thereafter, I have made representations to the authorities concerned. My lord, my last representation is at page 29 for taking immediate steps for repairing of that embankment, my lord, as well as, my lord, to drain out the saline water filled
Yes,
for my land.
Should not be considered.
Yes.
They say there's nothing done by them. They say that uh, the private respondent has been using an underground pipeline, and there is no cutting of embankment.
My lord, that's there, my lord. I have let them, my lord, let them file an affidavit to this effect. I'll use my exception. with the proof that,
What will happen ultimately? How will the report decide on?
with the proof, with the photograph can show whether a river has been, the embankment has been cut down or not. The nearby lands are filled up with saline water.
The petitioner alleges
was executed rent agreement, lease agreement, and the bank was paying money. The agreement was executed 2007. There was no dispute. However, in 2018, the original owner died, and thereafter the bank has stopped paying, my lord, the rents. And my lord, the formal agreements were not being executed. We have made several representations that has not been complied with. So I have talked with my learned friend, my lord. She has represented her client. The banks are willing to occupy to continue with the tenancy, with the lease after execution of fresh agreement, and in the meantime they have agreed to liquidate the dues, whatever rents.
My lord, yes, my lord.
This
So,
is-
my lord, we are there. We are not going to run away. We are there. We will remain there. They have not taken any steps to evict us or whatsoever. But the constituted attorney should not negotiate. They come and negotiate with us, and we.
Madam,
will
we
do
don't
what
have
is
it. We don't have it.
good. And
Because we don't want,
And I'm aware that bank is state, under state and maintainability point, but I have two judgments, so far as the landlord tenant dispute is concerned and the maintainability.
Why, if you are amicably settling, why are you fighting with this?
He may approach the bank is willing to negotiate.
but
with
why,
us.
what I understand, my lord, the particular power of attorney will not approach because she is a widow, my lord, and there was some difficulty because
Why, what is the problem with the power of attorney approaches? Why do you want the person to come to you?
That is what unofficially has been told to me. He's creating some pressure on the bank and he's making big talk. The
So if
officials are not.
somebody is ill, she is a widow, you want him to come, then
The daughter is
then the
also
court is not powerless to evict the bank,
there.
even in this petition. This is not done.
Also there.
You will enjoy somebody's property and you will ask him to come or her to come on your own terms. That is not right.
Not really,
Then-
but I will communicate, they may approach the bank.
we will approach, my lord. We want, because at this is not our intention to evict, because we are now without any income. My husband died, and this is our board of
The kinds of them. This is unfair. Unfair.
From my end, I will
because to
communicate.
maintainability, I should not, my lord, open my mouth.
From my end, I shall make all the efforts to let this negotiation work. They may approach the bank officials, they are willing to negotiate.
Very well, and then keeping it pending, you come and say that it has been settled.
My lord, I will make make my client
Lieutenant?
understand, I will make a representation, proper
It is
representation.
submitted by both the parties.
I'm asking for not today, most matter, Lordship.
He is in difficulty. Why? What is the problem?
That too, this matter is adjourned for third time.
Lordship, on the last occasion, we are here, Lordship, it was to.
These are.
I am not opposing to that.
Then don't say this. It is for the third time or fourth time. He has not
Okay.
paid for adjournment on earlier occasion. Yes, next.
বলতে পারছি আমি বসে থাকতাম।
Call for next.
For the WBCL, my lord, read by Mr. Naik, Mr. Srijan Naik. My lord, there is a typographical error in the last occasion, my lord. Before he submitting, my lord, there is a typographical error in appearance, my lord. It is Srijan Naik instead of.
We'll correct it. We'll correct it. Yes, who is for the petitioner?
For the petitioner, I was here for short passover.
Passing it over. Let us see if he comes. I'll come back after 12.
I think attending number 30.
Ask him to come. Yes, next.
Lordship, I beg to appear for the petitioner. Lordship, on the last occasion, my client had visited the courtroom from where the certified copy is to be given to him. From there, he has got information that the certified copy is ready, but as the staff in charge is on leave right now, after 11 February, he will receive the certified copy. That is the instruction given to my client.
So what should I do?
Lordship, kindly dispose it off with this observation that that he will receive it from the court.
When I'm passing it over after 12, when I take it, you. I'll take the email on record and dispose this off. October করে রাখছি 12টার পরে call করো। Yes. Yes.
Like 32, Mr. Resolution of the petition, not to the office.
Milord,
Why did they not today? Last
Milord,
time-
I am appearing on behalf of the state, Milord.
Kindly accommodate.
There is a report, Milord, submitted by that video, Milord, that the petitioner has applied for withdrawing the subject matter, Milord, from the court, Milord. So it's law here, Milord. That is last page of the report, Milord. There are two-fold payment to be done, Milord. First, we have order already paid by the competent authority to the petitioner. And last page, that petitioner has submitted an application addressing to the advocate to withdraw the subject matter from the court.
Very well. Listen into it. এটা ফেরত দিন ওনাকে।
And kindly that should have a copy of this report.
Four 33. Your Lordship, I am appearing for the petitioner. On the last occasion, Your Lordship had directed me to file my affidavit of service, Your Lordship. I'm filing the same. Your Lordship, there's some urgency in this matter because there's cyber crime involved, Your Lordship. This is a case of a credit card fraud, Your Lordship.
Why do you serve to email and all?
Your Lordship, because post it last time we did it through post, it came back.
There's no service. Email nobody recognizes. And even I don't trust these email services.
Your Lordship, they had appeared once. Your
Nobody had appeared. No, the order sheet shows only your name, and that is on 9th of January 2026. Before that, there is no order. No one had appeared at any point of time. Only you had appeared, and that also on 9th of January.
Lordship, in the last year when the matter had come up, they had appeared, but it was a not today because someone had sought a note.
So then there is no appearance.
Lordship, I can try through hand delivery because through speed post it came back, Your Lordship.
Email is no service at all. There is no proof of service. You can show, somebody will say, I have not received.
I can try once more through hand delivery, Your Lordship.
How have you served the police authority, state authority? They are important.
Yes, Your Lordship.
Then where is the service on the police? There is no service on the office of the ombudsman also.
Lordship, my advocate on record has been in the hospital. That is my difficulty. Lordship.
In what?
Your Lordship gives me one more opportunity, Your Lordship. I'll serve by hand as well.
Last के लिखे दिन affidavit of service filed today is taken on record. Service is not satisfactory. এটা উপরে লিখে দেবেন ফুল স্টপ তারপরে যেটা বললাম সেটা ঠিক আছে হ্যাঁ কল করুন 31 জি নোট এখনই পাঠিয়ে দিচ্ছি। But how do I know that it does not say that certified copies will be made available?
The second page,
Second page what?
the last portion. Certified copy already ready. Present given out already.
Okay, 30th January 2026. And this is what date? 29 January. It says certified copies are still lying in the copying department.
Copy already ready, but the clerk is
Yes, Lordship. That is what my client also said, that the clerk who is in charge of this thing is presently on leave. He will return on and from 11th February, on and after 11th February.
लिखे नहीं learned advocate appeal
My lordship, I am for the petitioner, my lordship, praying for adjournment for 1 week. Mr. Sauritra Ganguly appearing in this matter, his father, advocate and deputy, his father expressed few days before. That's why I am praying for adjournment, my lordship.
My lord, I appear
I
for
am
the
for the respondent number 7, my lord.
I appear for the respondent number 6.
This kind of.
Just 1 week, my lord. Just 1 week.
Yes, yes. I know your lordship,
Nobody
Mr.
can-
Ganguly's
can-
father
This
expired.
is the reason nobody can oppose. An accommodation is prayed for on behalf of the petitioner. Full stop. It is submitted that the father of the learned advocate on record for the petitioner has expired. Full stop. In such view of the matter, list this matter on when should I keep it?
Sir, just 1 week. Miss Friday, please. Is available.
On February 13th,
It's available.
2026. 13th February.
Deeply obliged.
Yes.
Deeply obliged.
Gratefully, your lordship.
You are appearing for whom?
I am
appear
for
the
respondent number 7.
and I appear for the respondent number 6.
Mr. Vasudev Mukherjee for respondent number 7. There is somebody else also appearing for respondent number 7. Please, you sort out amongst yourselves and give one name after finalizing. We'll record that.
Yes, yes.
I told you, Mr. Vasudev Mukherjee.
I am file wakalat number. Item number 7. I respondent number 7.
You give one name. Whoever is appearing, give one name. Both names will not be recorded. Sort out amongst yourselves.
Yes, yes. Respondent number 7, your lordship. Myself, my
There is
name be
someone
recorded.
else also appearing, Mr. Mukherjee, for respondent number 7. You please sort this out of court and let the court know who is appearing finally. Yes, next.
Yes, yes, my lord. Yes.
Wait to my lord.
Respondent number 7 তো তুই দেখে এই তো দেখুন respondent number 7.
The petitioner has come. No, he has come. The petitioner has come. It's ঠিক পাঁচবার তো কল করুন। Yes.
No, last occasion, your lordship was pleased to direct the private respondents to take instruction from his client.
Why are you not paying the money?
I myself is in a position, Malad, cannot say this because Malad, I'm saying is that Malad, the order, Malad, basically passed by Malad Justice Subhasati Bhattacharya was challenged by my client.
But in appeal,
thereafter we have preferred appeal, and in the appeal also we have. Malad, since before that I have filed the Bhokalamna by this in this matter, so I have, as an officer of the court, I was supposed to appear.
Very well, if you don't appear, you don't appear. I will have to now initiate appropriate proceedings
Yes,
for
but
the appeal.
I will say that, Malad, I don't have any instruction to that. I have tried to call my client.
That I am not going to record all those things. I will then,
Malad, Lordship,
service has been effected.
Yes, Malad, Lordship,
Service has been effected. If they don't appear, the district magistrate will take up.
since my Bhokalatnama is there, I am appearing. Malad,
You have
Lordship,
to appear
kindly
if
call-
Vakalatnama is there.
yes, Malad, so that's why, Malad, I am saying the necessary process of law that may be issued. I don't.
Yes, sir. How will the DM execute the order? If they don't pay, what will the way out? That was the question put to the learned advocate.
But I have gone through this. But with my limited knowledge, Malad, I couldn't come with a proper explanation to your lordship. Rather, I must surrender before your lordship. I must be candid. Because once I was under consideration, Malad, there might be a direction of this court to take steps in accordance with public demand recovery. But Malad, unless it's a cost imposed by the court, perhaps that would not be the proper course of action. So Malad, one thing is there, since everything done or initiated by order of this honorable court, this honorable court has ample jurisdiction to get it implemented. That would be another, if the lordship don't take me as a means, but I would be making a submission for lordship, let there be a direction for personal appearance of the private respondent. Because in some cases, personal appearance may resolve the issue. Because my learned friend is not taking the responsibility.
But how can I?
No, neither he can apprise this court about the present status. Well, let him appear before lordship and let him once say that he is not ready to comply this court's order. Yes. They are not an individual, my lord. They have been running up cable operator. They are the cable operator. They have illegally using the, my lord, electrical pole of electric supply department.
Listening. I am fixing it for order and pass my order.
But in that regard, my lord, we had filed an affidavit dated 11th of September 2025, which was,
How did you serve the police authority?
my lord,
By
we have
court?
served.
We have found the documents.
By speed post.
They are not appearing even then. This, give me this.
One of our considerable times of hearing. Now, the problem can be resolved by that committee, which is a part of the panchayat and the.
They are not appearing, they are present not to appear. What can be done?
My lord, this matter pertains to social boycott. My lord, your lordship will be, Mr. Lordship kindly takes up the affidavit that we had filed on 22nd of December 2025. My learned friend says the correction that if the committee is made a party, but if your lordship kindly takes up page 17 of my supplementary affidavit, the office remains closed. And my lord, very surprising, my lord, we had heard specifically with regard to the report filed by my learned brother, my lord.
So see, this photograph will not prove
But
anything.
as of today, my lord, today also it's closed.
How will this court?
Yes, my lord, I
decide
understand,
that?
but
Because the lock is there, how will I know it is there for all 24 hours? For what period of time?
today also, my lord, I had received a video call that is closed. Yes, my lord. My lord, may I just indicate to your lordship, my lord, if your lordship kindly takes up the report, their report, wherein, my lord, they have stated that 5,625 is pending. But this amount is only payable by a person, my lord, only after receiving the water supply. My lord, we had specifically categorically stated in paragraph 4 of my supplementary affidavit as to how this amount is calculated. Now, in 2020, my lord, we were under lockdown. But so far, we had utilized, we have paid it. Thereafter, no water supply, we did not pay it. Even in my lord, we had made an attempt to pay that amount. Paragraph 6, 7, and 8, my lord, we had specifically averred as to why this payment is not being allowed to be accepted by them. Till today, my lord, water supply is not there. And that is the only source of my livelihood, agriculture.
And who is stopping you?
But the private respondents, the states are the
private respondent means? There is no private respondent in the writ petition.
No, there is no private respondent. The basic issue, my lord, is with regard to the Pradhan is not supporting us.
No, that is not the.
Of the Gram Panchayat has to.
My report was to that effect, that during inquiry have will come for a total committee. I have raised my voice several times from the last few officers that this committee has to be made a part. Now, if my honest friend cases that Pradhan is involved in this committee, then the Pradhan has to appear or directions has to be upon the Pradhan.
So why don't you add the committee as a party and serve them?
May I just submit?
More than 3-4 months.
What is?
No, there is no problem. If adding.
Solve the
Yes, we'll add them. We'll add them. That's not a problem.
Unnecessarily, it is being we come to square one again today.
Yes, my lord, I accept
Next
it.
day you will
But,
come and we'll be.
but
we'll
my lord,
be
on the
here.
last occasion.
He has been raising the subjection every
Yes,
time.
yes, I understand, my lord.
Then add him, bring him. And if
And
he
I
doesn't
will,
come, I'll
but the
give the
difficulty
order.
is, my lord, we have stated in paragraph 7, this Badal Madhi, who is the cashier of this committee, he doesn't accept it.
Let him not accept it.
The
Pradhan
Pradhan
should be there before the court.
Yes, my lord.
How will the order bind?
Through the police officer, my lord, we have served the Pradhan. Even
Pradhan
today
is not the committee.
But he is the in charge of the Gram Panchayat. He should be looking after that.
If there is a committee there,
we'll add him. No problem. We'll not
the committee has a juristic recognition. Then what will be the use of making the committee a party? Whatever may be the allegation.
And this committee is closed, my lord.
Because there is. Please listen to the court first. Because there is some body which does not even have judicial recognition. What will be the use of adding such a body as a party? I say that I am ex-limited. So I should be added as a party.
And the office remains closed, my lord.
At the most, we can produce this protection if during installation or supply there is a dispute. We cannot provide the water consumption. Until and unless.
But the state should ensure that the citizens get their water supply.
How do you get the water supply? Where have you written that? What is the modus operandi to get the water supply?
But the backdrop.
And where from will I get that the Pradhan is at the hem of the affairs of the committee?
Because I am belonging to that Gram Panchayat.
That is nowhere. Show me from the petition that the Pradhan is at the hem of the affairs of the committee. Answer things which
Well,
are
I
legal.
understand.
Don't give arbitrary answers.
But kindly takes up paragraph 6 of my writ petition. Here the issues start. And for every cause,
Nothing is written here.
may I just submit one thing?
Nothing is.
For
Please
every.
don't submit anything else. I want to know something. Please, you can answer that. Please answer that. Otherwise, there is no use here.
But kindly see my paragraph, page 72 of my writ petition, the annexure. This is the representation which I have written to them. Specific allegations is there.
Let the Pradhan be personally present. That will solve the problem. Yes.
Grateful.
Take all instructions and come.
Yes, sir, that will be better, my
Very
lord.
wastage of time.
Grateful.
Very good. Yes, call করে দিন আরেকটা একটু।
আমরা পুরো আবার আগে।
My lord, I am for Bank of India. I tender my unconditional apology for being late.
You are appearing for the. Yes.
But by upon now, state parties were appointed as seven. The petitioner is Pradhan Purohit as appointed by the document. That is actually one of the starts at page 11. Page 20.
Yes.
Seventh line from the bottom. সেবায়িতগণ সর্বসম্মতিক্রমে ভক্তগণ মোড়ক that is petitioner প্রধান সেবায়িত করিলেন যুক্ত প্রধান সেবায়িত আজীবন অস্ত্র অপরনামা সম্পূর্ণ সর্বপ্রকার রক্ষা পরিচালনা করিবেন Now therefore, and I was appointed as প্রধান সেবায়িত. Now subsequently, bank account has been opened as I have known of.
Bank account has been opened in whose name?
In the draft name in the I gave him RTI before the bank. And RTI has given a reply. This is page 36. According to the first reply, as the clause 2, our Purika Bank has informed that as per deed, that Purika Sevai will have the power to take decision regarding the property account of Pushi Talunaka account. No special powers according to this conferred to Pradhan Sevai, hence bank has opened the account. This is the reason for opening it. But my lord, from the outcome now, it will appear, my lord, that I am the second choice, and if it is found that some of the Sevaites are not there, in that even question of majority decision will be taken. Decision of the majority Sevaites will come, my lord, when my lord, all these Sevaites are not available. Otherwise, my lord, so for the Pradhan Sevai is concerned, at page 20 that will do. Therefore, I being the Pradhan Sevai, my lord, I should be knowing everything about it. But one of the bank has not given me. Subsequently, I made another application before the authority. That is at page 45. Page 44.
Yes.
This application is pending before the bank, but in the meantime, submit application. But I the supplement it's put towards file.
By whom?
By us. Paying for declaration of, and in that group has covered 6 days. We might have a partly. So for account is concerned, well, that has not been granted, but so for declaration, I am in Pradhan group that has been granted. No, this is the supplement. Other portion at page 19.
It is. Page 19.
And this is the already portion.
Yes.
That the expense should be and the same is discrete in part and content in favor of the plain good as against petition number 1 to 7 and in favor of the petition number 27. It is thereby declared that plaintiff number 2, namely Hospital Murdoch, is the Pradhan Sevai in terms of the Oppenheimer dated 3rd of June 1989, not as Exhibit 1, and is entitled to perform all such duties and functions as written in the Oppenheimer deed, which the authority to manage the property of the deceased services. Therefore, now, my lord, bank cannot say that because the majority Sevai has produced the resolution and therefore the bank has been authority. My lord, thanks, my lord.
allow me to operate to that.
No, but Mr. Mahato, this decree does not say that you are entitled to operate the bank account. It says that you are entitled to discharge your duties as a Pradhan Sevai. Whatever rights a Pradhan Sevai will have, you will have. Now, whatever rights a Pradhan Sevai is supposed to have will be in terms of the deed. If the deed says that you have a right to operate bank account, you will have rights. Otherwise, you will not have rights. Nothing comes from this decree.
Also now, page 18.
Page 18. 1/8.
Part 459. The names are given.
Page 18.
Page 18.
1/8, yes.
The Bhaktavan Modok, the names are there number of 8 names. Lastly, Sopan Kumar model.
No, page 18, there are no names.
And last, I have 7 lines.
Yes, I'm seeing the repetition only. Page 18.
Yes, last 7 lines.
Last 3 lines, সুখ সম্পত্তির আয় সংরক্ষণ করিবেও।
Yes, before that one, and to argue to buy the Calcutta.
হ্যাঁ, তো 8 জনকে সেবাইতে
Before that, my lord, exams are there.
তপন কুমার মোদক। তপন কুমার
Bhaktavan Modok, 26.
Last is Sopan Kumar Modak.
Last is Sopan Kumar.
Yes.
First is Bhaktavan, who is the petitioner.
First.
Number 1.
First is Bhaktavan Modak. Yes.
He is the petitioner.
Yes, I have got that.
So, I will say, Sevai নির্দিষ্ট করলাম, সেবাই সমন্বিতভাবে ওই সকল সম্পত্তি তত্ত্বাবধান করিবেন, সম্পত্তি আয় ও বিপত্র সংরক্ষণ করতে ও সেবা পূজায় উক্ত ইমারতের আবশ্যক মেরামতি কার্য করিবেন। সেবাই যে তত্ত্বাবধান কার্যটি একমত না হয়, তাহা হইতে অধিকাংশের মতামত কার্য করতে পারবে। But therefore, the condition is if there is difference of opinion in that event, my lord, majority will come. But here, my lord, there is no case. Nobody's case, my lord, that we are not in same opinion. Therefore, my lord, my presence is necessary. Because I am the, and I am already told, my lord, that I am the Pradhan Seva. So in my absence, nothing can be done.
Yes.
My lord, my learned junior is there to hand over the resolution, copy of the resolution, on the basis of which we have acted, my lord. Or
show me the resolution. My lord, the resolution is in page number 36.
Page 36.
He's starting from page number 33. Then in this resolution, Madhusudan Modak has been appointed to carry out affairs of the Devotar property.
First paragraph, my lord, অর্থকাজ নয়, আমাদের ব্যক্তিগত উপস্থিত না থাকার কাজ পরিচালনা করার জন্য মধ্যমতা অনুষ্ঠানকে ভাগ দেওয়া হয়েছে। I was never intimated about this building. Never intimated about
Then also, Mr. Mahato, why his court will intervene in all this? All that I can direct is, I can direct the bank to consider your representation upon hearing both of them.
my lord,
I have my that.
That is all that I can do.
my lord.
Very well, the bank will hear all of you. Listen, this petition alleges arbitrary action on the part of the bank in allowing the respondent numbers. Who are the respondents who have been allowed to carry out the transaction? No, your specific allegation is against whom?
Madhusudan Modak, 5 to 11.
Respondent numbers 5 to 11. But he, respondent number 9 is supporting you. Yes, Mr. Mahato. Your allegation is that they are conducting the transaction. Except man. Yes, taken it. Alleging that the respondent numbers 5 to 8, 10 and 11 have been alleging arbitrariness on the part of the bank in allowing the response on the part of the bank. Type start করলাম in allowing in allowing the respondent numbers 5 to 8, 10 and 11 to conduct banking transactions in respect of which account? Savings account. In respect of
And page 32 bank's document, my lord. Page 32.
in respect of account number এই এখান থেকে পেজ 32 থেকে মিলিয়ে নেবেন 412-810-11-000-1234. In the name of Sri Sri Kalimata Trust. That is the name. At Sorisa branch of the respondent number 1 bank, i.e. Bank of India. Full stop. Paragraph. Mr. Mahato, learned advocate appearing for the petitioner, submit that in terms of the provisions of the Orponnama, the Pradhan Sevai is supposed to be a part of every transaction conducted in respect of the trust, and it is only if there is a conflict of opinion that the trust can be managed or transactions can be conducted on the basis of the majority opinions of the Sebai. Full stop. That is the submission, Mr. Mahato. Full stop. It is submitted that in the case at hand, the respondent bank has proceeded to allow the aforesaid account in the name of the trust to be operated by whom? By respondent number 5. Respondent number 5. By the respondent number 5, i.e. Madhusudan Modak. Full stop. 5 and 6. Respondent number 5, i.e. Madhusudan Modak, and 6. And respondent number 6, i.e. from Munas Modak. Full stop. Paragraph. Learned advocate appearing for the bank submit that the bank has acted on the basis of the resolution provided to the bank.
मम्मी इनके ऑफिस से कुछ दोस्त आए हुए हैं तो मैं बाद में कॉल करूं?
Provided to the bank wherefrom it would be evident that majority of the Sebai have been conferred authority to take decisions regarding, inter alia regarding the bank account of the aforesaid trust, and that no special powers has been conferred on the Pradhan Sebai. Full stop, paragraph. Learned advocate appearing for the respondent number 9, comma, submits that the bank has misread the Orponnama and that the Pradhan Sebai must be included. Your contention is also that?
The resolution I was ignorant. But
The Pradhan Sebai must be included. And that then what is your submission? He should be part of the. And that respondent number and that the respondent number 5 and 6 are mismanaging the bank account. Full stop. It is submitted that misread the Wakalatnama, misread the Orponnama ka kete din. That is not his submission. Oporetta, learned advocate appearing for the respondent number 9 submits that the respondent numbers 5 and 6 are mismanaging the account. Are mismanaging the account. Are mismanaging the bank account, and that the respondent number 9 has also made representations in such regard to the bank. Respondent number 9 submission. Next. Third learned advocate appearing, Mr. Mahato, learned advocate appearing for the petitioner, has Mr. Mahato, learned advocate appearing for the petitioner, seeks leave to file a supplementary affidavit, bringing on record a judgment and decree. What is this? Decree or an order? Judgment and decree passed in title suit number 146 of 2016, instituted by the you are also a plaintiff. Plaintiff number 2. Instituted by the petitioner along with others against the respondent number.
Plaintiff was the petitioner and the respondent number 11. Upon Kumar Modak and my lord.
No, who are the defendants there? Shambhunath Modak and others.
My lord. Others are my lord the respondent.
So all the respondents in this writ petition are the defendants there against the respondent numbers 5 to 11.
No, 11 is my lord plaintiff.
5 to 10. 5 to 10 against the respondent numbers 5 to 10. Before the learned civil judge, junior division, within bracket, second additional court at Diamond Harbour. Full stop. Such leave is granted. Supplementary affidavit filed today is taken on record. Copy thereof has already been served upon the learned advocate appearing for the respondent. Mr. Mahato, learned advocate appearing for the petitioners, draws the attention of this court to the decree passed by the learned civil court in title suit number with such and such 146 of 2016, and submits that in the civil court, the civil court has put its seal of imprimatur on the petitioner's right to perform all such duties and functions as indicated in the Orponnama as the Pradhan Sebai of the aforesaid trust as also to perform the obligation of Seva Puja. Full stop. Paragraph. It is submitted that in such view of the matter, comma, the bank should be directed to amend the mandate of operation of the account, permitting the petitioner to be a part of the person entitled to operate the bank account. Full stop. Third, learned advocates appearing for the respective parties and consider the material on record. Full stop. Paragraph. Since the issue involves the interpretation of the Arpon-Nama, by dint whereof the petitioner has been made the Pradhan Sebai of the trust, comma, by dint whereof the petitioner claims to be the Pradhan Sebai of the trust, comma, and such issue has already been raised before the bank by way of a representation dated September 6, 2024, by the petitioner, comma, it would be appropriate to direct the bank to consider the said representation and take appropriate decision at the first instance, comma, without this court going into such issue under Article 226 of the Constitution of India. Full stop. Paragraph. Accordingly, comma, the zonal manager, comma, Bank of India, comma, Kolkata zone, being the respondent number 2, is requested to consider the petitioner's representation dated September 6, 2024, and decide the authority as regards operation of the account of this savings account in question of the trust of the aforesaid trust upon affording an opportunity of hearing to the petitioner as well as the other signatories to the resolution on the basis of which the said account is being presently operated. Full stop. That will suffice. You are being heard and the other signatories are being heard. No other person is required to be heard. So you are also being heard. All the respondents herein are signatories. That is why I said I have not limited it to respondents, I have said signatories, because the signatories to the resolution are the only persons on the basis of whom, so signatories will suffice, even if somebody is left out here. Full stop. And such other persons whom the bank feels interested in terms of the Arpon-Nama. Full stop. Paragraph. It is expected that the bank shall take expeditious decision as there are allegations as regards mismanagement of the account. Full stop. Comma, and shall dispose of the petitioner's representation within a period of 3 weeks from the date of communication of this order. Full stop. Paragraph. WPA 2770 of 2025 stands disposed of with the above observation. There shall be no order as to.
And will act on the server.
Yes, that is always there.
Otherwise, again, they will demand for
The party shall act on the server purposes.
Apologies, my lords. My lord, I'm appearing for respondent number 2 in item number 836. Apologies, there's been some error on our end. We weren't able to see when the matter was called out. The display board didn't mention when 8:36 had been taken up.
It has been
I would
adjourned,
only,
madam. The other side was there.
my lords, for respondent number 2, the petitioner was not there. We simply wanted to make one submission, my lords.
Not
Which
now,
is
madam.
that the
Nobody
prayers.
is there. I will not take it out of turn like this. Yes. Chalo, next matter. Call.
138, my lords, and the state respondent, my lord. Last occasion, my lord was used to hear out this matter, my lord. That's a tender matter.
Oh,
my lord.
yes, yes.
Football Chaturthi argued that matter, my lord.
He's not there.
She's not there, but
I'm making it not today unnecessarily. It will be taken up again on the next one. You were to respond. You were to respond to his submission. You had begun, but you had not yet concluded. So he is required to be here. I'm recording an order. None appears for the petitioner.
Lord, here I have challenged an order about passed by the ombudsman, insurance ombudsman, page 44.
Page 44.
Page 44.
Yes.
Only 3 lines order. Lord, before.
Yes.
Lord, before that, your lordship kindly turn to page 34. The order passed by the my lord insurance company. My
34.
lord, against my claim.
Yes. This
Lord,
is not admissible due to misrepresentation of
yes,
fact.
because my lord, what happened? My lord, my vehicle, my lord, met an accident within the my lord insurance period. And my lord, due to some my lord, that my lord, accident, my lord, the cabin my lord damaged. My lord, the view of the insurance company, since the driver and his helper, my lord, they have got no injury. So this is misrepresentation of fact. Only this ground. Lordship, can we see page 34?
You got it.
3 lines order.
Very well. So you are appealed against this before the ombudsman.
Ombudsman.
What
That
is
was
the-
also page 44. But if I am not wrong, my lord, it is the repetition of the my lord, insurance company's order.
Page 44 is only here.
No, my lord, page, my lord, 1 minute, my lord. Page 46, my lord, pardon me.
But sir, if there is such a serious accident that the entire cabin and
My lord.
everything is damaged, how will the person inside it
My
not
lord,
suffer
my lord,
any
I am bowed down to your lordship, but lordship, I am only, my lord, giving one instance. My lord, very recently, my lord, the air crash was, and my lord, one person, my lord. So, my lord, if
one person was saved is
My
another
lord.
thing, but he will not suffer any injury is a different thing.
my lord, that is, but damage or the accident is there, there is no, my lord, my lord, document that no accident took place.
Doctrine of obedience.
Like no accident took place, there is no document because my lord, I have also annexed the my lord, photograph. My lord, page 29. So anyhow, my lord, God save us. Anyhow, God save us. And my lord, the complaint was lodged at that time, my lord,
But,
to the local police station, page 20.
Sir, the report, the order is at page 31.
Yes,
My lord,
starts from the.
You have shown only the communication. That is not the order.
my lord.
Order is a detailed order.
Not, nothing forward,
Page
my lord.
34 is not the page 34 is not the order. Page 34 is only the communication of the order.
Communication of the order.
So why are you placing this? This is the actual order.
Yes, my lord.
Yes.
They are not considered any medical reports. Guys are not the help. But my vehicle, my lord, damaged due to accident.
That
It
has
is
to be
with the-
proved.
my
That has
lord.
to be proved. It can't be on the basis of the contention of the person concerned.
Because, my lord, if I had not, here is mentioned that the car was damaged, but no, you know.
There is an investigation report which has found out certain things.
এই পেজটা দেখতে ফটোটা দেখতে বোঝা যাবে।
Confirmation and conclusion. What types of confirmation and conclusion?
দেখিয়েছেন, ওটাও দেখিয়েছেন, এটা দেখালে বোঝা যাবে না। No breakthrough. Breakthrough on. That one. Orange. আপনার
Very well. Today there is no time more.
So, my lord,
Second half, I'll be taking up application matters.
my lord, fixed any date, my lord. Well, lot fixed, my lord, time.
only one thing, Madam, I'm appearing for respondent number 4, man. Only one thing, Madam. This kind of appeal.
Not now, not anymore.
Great.
Heard learned
But
advocates
my lord,
appearing.
let them file affidavit, my lord.
Heard
for
learned
affidavit.
advocates appearing for the respective parties. Full stop. List this matter for further consideration on February 13. No, February 13, 2026. 13th February. I've said heard.
My lord.
I've started.
My lord, on my behalf also. Respondent number 4.
Yes, yes, I've said heard learned advocates for the respective parties.
May I have your lordship's kind leave to correct myself in respect of 834, item number 834.
Which one? What has happened? 836, what has happened? So you on that day you appear and say, other side was there. I have not dismissed it today. No. It
Deeply
will
appear.
appear as for dismissal on some day. Whenever I have kept it, you come and if you come, I'll
Deeply.
hear you. It has not been dismissed for default.
No, yes. I will. Deeply
May I have
appear.
your lordships
কবে
kindly to
রেখেছি for
mention I.
dismissal? Paper book? Paper book কার? ওটা এমনি করে দেবে, এমনি রেখে দেবে। ও বাচ্চার অসুবিধা হয়।
May I mention, my lord, item numbers 41 and 42
ওটা
subject to your
মনে
lordship's
করিয়ে দেবেন,
leave, my
অর্ডার
lord.
কে দিয়েছে? শুধু লিখে দেবেন adjourned for the day. No, don't give your appearance. I will not put it under to be mentioned. It will retain its position. Because that will be unfair to the other thing.
Lordship will kindly permit me to mention items 41 and 42, my lord. Item numbers 41 and 42 are matters where I have been blacklisted as far back as 9th December 2024. Lordship had heard this matter on the 2nd of January 2024 and directed the respondent, Gun and Shell Factory, Kashipur, to file an affidavit in 2 weeks. They have not yet filed their affidavit. Today also, my lord, they have informed my learned advocate on record that they are unable to file because there's some change in their internal office. So, my lord, I was praying, since your lordship was of the view that this has to be heard on affidavits, if the shortest direction can be passed and the matter can be made returnable, my lord, because I have been blacklisted since December 2024.
They have that. They were yours.
Because it's almost 1:22, so I can't expect them to be here. If you can bring them,
Then, my
I'll pass the order.
Yes, my lord. Any short date, my lord, for affidavits and the matter can be heard because I've been blacklisted without a hearing.
2 p.m. another list is there. Please see the list. It's there.
So
Grateful,
we'll
my
ask the other side to be here. Yes.
already informed the government leader, my lord. He's on lake before court number 37. He's coming just from court number 30. Kindly just you have short pass over, my lord.
Your other side is there. What will I do? It's there in the list. It will be called on next Friday again.
Within 2 weeks.
This time they know that the list is going to proceed differently. So if they are not here, they are justified in not being there. I cannot pass an order against them now. It will be there in the list as it is. It has not been called. Out of turn, I will not pass any order at this time. There is an indication in the list from 2 p.m. I'll be taking on something else. And at 2 p.m. I pass an order in a different matter. It is almost from the top. It has appeared only today, isn't it? Oh, passover taking. Application গুলো কল করুন উনি এলে তারপরে
For the respondent. I am appear for the applicant, petitioner.
What is the plan for?
As per direction, lordship, I have the copy of the statement.
What is this can for?
Lordship, this is a can for appropriate. Can 2 is the application for appropriate order.
You are appearing for?
My lord, I am appearing for the private respondent 5 and 6, my lord, the son and the daughter-in-law of the petitioner.
Yes. The matter relating to senior citizenship.
Yes.
The petitioner are the owner of the said property. That at that point of time, the private respondent are not getting entered.
You are in possession of the property or not?
Now I am the possession, my client is the possession of the said property, but as per last order of the Honorable Justice Rajasekhar Mantha, the petitioner occupied 1 room. But now, lordship, the petitioner constructed a separate plot of land and he constructed a building, and on the said building he resided, but in the same room which was allocated as per order of the Honorable Court, the petitioner, the private respondent are locked key of the said room, and he is not used of the said room. But the said room was damaged day to day. I filed the application for vacating of the said room also. Not necessity, the private respondent has no necessity to occupy the said room. He decided separate plot of land of his own house.
That in effect, if lordship would appreciate, my lord, in effect, my learned senior is vouching for a modification of an order passed by this honorable court, my lord. My lord, lordship knows, my lord, if he wants to seek a modification, my lord, he has to go before the same bench which has passed the order. Number 1. Number 2, my lord, lordship knows, my lord, his initial allegation against me was that I am not allowing him to enter his own property, my lord. I am not giving him food. I am harassing him and all that, my lord. Today, my lord, his own admission before your lordship is that, my lord, that I am not doing any of those, my lord. The initial case that was made out in the writ petition is not what he is making out. He is making out a completely new case in this through this can application, my lord.
He was not filed any opposition also last 3 years. Last successive lordship, see the order of the Honorable Justice Mantha.
Who has put padlocks on the room in question? Who has locked the room?
And the private respondent.
Why have you locked the room?
No, my lord.
By the last order,
kindly
this court,
yes,
a coordinate bench, had directed you to allow them to be in possession of the room.
They are in possession of the whole house.
His case is, my lord, if I understood him correctly, my lord, his case is that he is in possession of the whole house by the dint of the last order, my lord.
No, no, his submission is, and that is his case in the application, that you have kept it under lock and key.
My lord,
Lock and
not
key
the
of
house.
one room of the.
That is what. That he has been given the possession of the whole house, my lord. I have been restricted. I and my wife have been restricted to one single room of that house, my lord. His allegation is that I have kept it under lock and key. That is his allegation. He is enjoying the house as a whole, my lord. I am not even.
What is your problem?
I don't
He's
know, my lord.
having a room.
He is not use the same room. He decided
How is
another.
that, how are you
another
concerned
plot of
about that?
land.
Last court's order, last court's
That,
order,
that my
last
room
order,
was damaged. Day to day, he is not.
last order passed in 2023 was that you are not having access. You have access to the room, you have been there for 2 years. Suddenly, why do you want them to be out of that room also? You file a civil suit then.
I'm so grateful, my lord. So grateful. I'm so
This
grateful.
is not proper.
No, Lordship, that's as per act of the senior citizen court.
So you go before the court. The act of senior citizen is not before the high court. If you want everything for the high court to do, that is not proper. You have got an order, you are not satisfied. What kind of application is this?
Unnecessarily lock and key of the.
If it is under lock and key, you are also not residing there. File your opposition to this. You are not willing to hear the court, let him file his opposition. Can 1 of 2025
Well, subject to
is
correct.
an application
Direction to file a affidavit. Till that he has not filed an affidavit.
seeking, very well, seeking eviction
That your lord.
Lordship will find the operative part of the order at page 16 of the application. The entire amount has been secured. And now, my lord, your lordship will find that the bank guarantee has been duly furnished from the GST move 5, that is at page 19. Then, my lord, the 16 is the operative part of the order passed by the honorable court. No affidavit has been filed by the department.
Release goods in question subject to fulfillment of conditions.
Entire amount has been secured. It's about in excess of 7 lakhs or so. It's a very small. Everything.
Not to deny to cover because bank guarantee is secured. Nothing remains. Because
It will not do. What is your instruction? You have to say that.
This is the renewal. I can
Where is
share
the
it.
notice? Where is the notice, Mr. Notice. What is the subject matter of challenge, Mr.
Urgent matter, kindly take the notice at page 21. Every day, my lord, the officer is calling up the petitioner of the council. Page 21. So she will find you are directed to submit pay order. So we have secured the entire amount. The bank guarantee has been renewed.
kindly keep the main matter your lordship on Monday. I can come back to the
Otherwise, your lordship may kindly.
This bank guarantee was only for the purpose of release of the goods.
But entire tax, everything has been secured. The tax, penalty, interest, total amount is in excess of 7 lakhs. Well, at 121, one sees that if you secure everything, goods would be released. Goods have been released, but the amount which is the dispute, your lordship, that amount has now been secured by BG. The BG has been renewed from time to time. The main question which arises for consideration in this petition is very interesting. That how can an officer who is interjecting or intercepting goods in transit or movement of goods is not the competent authority to decide the classification of the goods. And on that basis, penalty cannot be imposed. Already, lordship will find from the interim order, I had cited 3 judgments rendered by 3 different high courts, where, my lord, this principle has been laid down. Number one, merits also, my lord, what is the petitioner? The goods involved is, my lord, the e-rickshaw in CKD, completely knocked down condition. My lord, our case is that when we are, if the goods are e-rickshaws in CKD, it constitutes the e-rickshaw itself and the tax which is applicable, the rate of tax which is applicable for e-rickshaw would be applicable to the entire consignment. The West Bengal, in the meantime, what has happened? The West Bengal Authority for Advanced Ruling has given a ruling that yes, if it is in CKD, tax would be charged, GST would be charged on as if it is an e-rickshaw itself and not on individual parts. So, the issue now also stands, covered by a fact-finding authority, being the WBAR. So, I will show all those authorities before your lordship.
Very well. If the entire amount is secured.
তুমি বলছো আমি ডকুমেন্ট দেবো কেন? তুমি যখন বলছো that's the last report. But Mr. Mujumdar is saying I accept it on the face of it. If Mr. Mujumdar says it, I accept it. I not put the paper.
Can 1 of 2026 is an application seeking an order of injunction restraining the respondent from giving effect to the adjudication order dated I'm disposing of the can link. Can 1 of 2026, can 620. List the writ petition for hearing in the monthly list of March. In the monthly list of March 2026. Password have to call please. There is a yes. What is he doing?
Malad, the
3/4 dates I have adjourned it for filing a report.
I've heard about it, Malad, it's very, Malad, I do not appreciate this kind of, Malad,
Why do they take the court so lightly? This is not right, because if it would have been a different court, he would have been here immediately.
Lordship is correct.
So if they are taking this court leniently, this can be done even by this court. It's not that.
Lordship, excuse this
It
matter
won't
for
look
the
nice.
time being,
It won't look
but
nice.
I shall,
They are public servants, but this, you see the orders, 30th of January 2026, 12th of December 2026, 28th of November 2026, 21st of November 2026, series of orders.
Malad, I've heard about it, Malad, Malad, I cannot defend this sort of action, Malad, on the part of the, Malad, the district magistrate. But, Malad, now that I find, Malad, there is a report. Oh, Malad, the report has come, but, Malad, it is the hard copy. It is just a printout of the, Malad, the soft copy. But this is not my original signature. Is
Very
not
well.
there.
So when do I keep it? I must have the report to proceed.
Monday, Malad. Monday, kindly, Malad, fix it, Malad. I assure you, Lordship, it will reach. It will be filed by Monday.
দিদি কি ফিক্স আছে দেখে নিন তো মানডে টিউসডে কিরকম কোনটা খালি হবে দেখুন সেদিন রাখুন because there are two things in one of the matters there is a section 14 order passed which has not even been implemented, leave about second execution. The property has not even been taken possession of and handed up to the bank. This is one. Second is order was executed, property handed up to the bank, borrower re-entered. There is a request from the bank to re-execute the order, which is permissible in law. The DM says it is not permissible. That I shall show the law when I pass the order. But it will come with very strong strictures, because there are at least 3 High Court decisions of our High Court also.
Yes.
We are carrying.
Give the judgment so that I can read.
It will be handed away.
Dean Copita.
Konta diye. Konta diye.
Oh, I'm carrying that.
Oh, it was 70 passport order diye. Oh,
Kanaicharan Panda is on different thing. Kanaicharan Panda is for not for that.
That then, my lord, this one only.
My lord, in Madhya Pradesh judgment, my lord, it deals with the other judgments which have passed.
This matter, my lord, I was relying upon the body.
Yes.
Not relying upon the system, but I had carried.
This matter refers to that earlier one in paragraph 38. That is the one which I was talking about. Cannot be said to be functus officio at the time of passing the subsequent order. Jurisdiction of CMM to pass subsequent orders in furtherance of order passed under 14(1) for the purpose of implementation of the order.
My lord, the Madhya Pradesh one, my lord, is also part of the point.
The logic is he is not exercising quasi-judicial authority. He is only an administrative authority to render assistance. So he will render assistance whenever I ask for.
Well,
it is not that I have become functus officio, now I will not. His functus
No,
officio is
this
something
plea cannot be taken.
where he is to act judicially. Honorable Supreme Court has, in a number of judgments starting from Balkrishna, that Ram Tarle, has held that it is only administrative. The moment section 14 is filed, that is why borrowers have no right of audience also. Without notice to borrowers, you have to decide. Earlier, they used to give notice to borrowers. Borrowers used to raise objections. Matters used to remain pending. They said nothing doing. If bank has made up, because public money is involved, that is the main concern. This is the main concern, because see, today if the possession is not handed over to the bank, then the auction purchaser has to be given the money. The court will have to direct the bank to refund the money to the auction purchasers. What happens? The loan remains unpaid. The same property will have to be put on auction again. Entire public money of whatever amount extent it is gets to stake again. The entire exercise has to be carried out merely because somebody feels that he has become functional office. That is not the statement of law. লিখে নিন কবে বললেন মানে প্রথম দিন বসে বৃহস্পতিবার সোমবারই then Monday at 2 p.m.
Monday at 2 o'clock is Monday, it is a difficult day. If it is Tuesday, it suits us. If it is Tuesday,
okay, we have fixed matters.
Subject to losses convenience.
Thursday করে দিন Thursday. As requested by learned government leader appearing for the respondent state authorities, list this matter on I have said that 2 p.m.
No, they will be done. Don't worry.
Mr. Leonard government leader is there, so that is why I asked him to come. And please ensure that he understands the law. This is not expected. There are so many
The
judgments.
administrative authority lordship know. They think they know better than anybody, including the lawyers. At times we are facing this problem. They don't understand. We have in one matter. Anyway, I can't tell you everything in court. But anyway, this problem is there. This bureaucratic arrogance.
Repeated I mean, pronouncements by courts, if that is also not followed, somebody may take exception to it in a different way. He'll
Yes, your lordship will deal with it. This bureaucratic attitude at times taking your lordship's time, court's time. I'm so sorry, my lord, for the inconvenience.
Thank you. Next matter is same order.
Yes.
There are two matters. Same order next সাথে উপর same order করে দিন দুটোতেই 824 825 দুখানা matter same.
We had a hard time.
I understand. I was also there, but this is unfair.
Very.
Too many orders of court you are not will. That means you are not willing to understand. It is not that it is not understandable. It's in plain English. Yes.
But I take the point of mentality of this can.
Can.
Yes, but I tell you why. My learned senior friend is very senior to us. He learned from. Kindly see his prayers. See his prayers, man. If this is a fresh cause of action, it requires a fresh consideration. If this is the prayer, all read prayers in a CAN application, it means it requires a fresh read petition. Is not in aid of the final relief, that according to his pleadings.
You want quashment of the notification. You want quashment of the proceeding.
I'm not problem is that I'm not aware of the number. I've not been served to 1237.
What is the main matter about? What is the main matter about?
Main matter is about that I have to buy the Kolkata Municipal Corporation with respect to the parking lot. But the parking lot was not belongs to the Kolkata Municipal. They authorized that to collect parking fee. As per the application number 12/2017, 12/2017, my lord, any services or any activity with respect to any function with respect to the municipality is exempt from tax. And as per Article 46, W, my lord, serial number 70, Article 243, W, serial number 70, my lord, public amenities, including issues like parking lot, bus stop, and public termination, fall within the purview of the activities of the powers of the municipality. So any activity with respect to any function trusted to the municipality, and this function of parking lot is entrusted to the municipality, and that is exempted one. So that is very short point, involved whether they say that I provide services to the individual. My contention is that I do not have any privacy of contract between the individual who is coming to avail the parking services on the road and me. It is between the client and the individual. I am busy affiliated agent. I am collecting the parking fees because the client has authorized me to. What is I'm just giving a abstract sort of an example. Suppose my car is parked on the road, and the road below the space.
What is the order that you have challenged? Adjudication order or appeal order? Why don't you prefer appeal against this? What is the problem in you preferring appeal?
Without jurisdiction, something.
How is it without jurisdiction? It is wrong interpretation of order, wrong interpretation of a provision. How is it without jurisdiction? This exempted or not is based on the interpretation of the provision. Whether it is exempted or not is based on the interpretation of the provision. He has wrongly interpreted that provision. How is it without he does not have jurisdiction to interpret it. He has it, right? The inherent lack of jurisdiction is one where he does not have jurisdiction to do that. These types of cases, every case will be lack of jurisdiction.
Difficulty is that this is a
Mr. Sharaf, there is a difference. There is a difference between lack of jurisdiction and an error within jurisdiction. If it is an error within jurisdiction, it is always amenable to appeal, because I will be entitled to approach the writ court if I can show that it is absolutely without jurisdiction. For example, DRT deciding a divorce case without jurisdiction. Civil court deciding a case which DRT ought to have decided. There is a bar without jurisdiction. You can file Order 7, Rule 11, get it quashed, nullity. But these types of cases where there is a gray area, where it can be, it cannot be. There is an error of jurisdiction. I have decided it wrongly. If I have jurisdiction to decide, I have jurisdiction to decide rightly. I have jurisdiction to decide wrongly also. Your remedy is appeal. You go before the appellate court. Why every matter before the writ court? Then what will the appellate authority will be absolutely happy. Appellate authority is very happy. We will be unhappy.
There may be the question of fact and law in any stream process. And if that is the case, then I should not be approaching the I will refer to the two judgments of the Honorable Supreme Court. It says that if it is a core question of law, then writ court should entertain that petition. But as kindly refer to the judgment.
There are equal authorities of equal weightage on both sides, Mr. Saraf. I can also give you 2-3 judgments against that, dealing with that. That is neither here nor there. But yes, Mr.
The show cause. We go back to the show cause. My London friend wants to. It says we do not agree that he is giving service to KMC. We say you are giving service to individuals, and that is a contention that has to be decided on May. Kindly see the show cause which starts from page 44. But that is the specific statement.
Then we'll hear the writ petition itself,
Yes.
instead of taking this application and hearing it, we'll hear the writ petition itself. But today it will be difficult for other applicants. Applications are supposed to be
Yes,
thought.
Lord.
When can we have it? Any day next week? Yes, Mr. Chakravarti, it will appear under the.
Senior friend would take half an hour. In the meantime.
No, half an hour business.
In that time, I'll get the time to study and whenever.
Interpretation, very well.
This is one of the matters where
I can argue, sir. But I can just keep repeating myself.
Correct. It's only question of interpretation. We'll also see, because then the matter gets finished. Unnecessarily application stage and read stage.
94 lakhs, but it may be appealable, my lord. By law, it is appealable. The question is whether it is applicated, whether it is possible.
Very well. We'll have it, Didi. এটা next Wednesday দিয়ে দিন। না, কোন দিন নি আমরা Thursday, Friday নিচ্ছি না এটা?
Wednesday মানে hearing matter can be মানে
হ্যাঁ, hearing এ দিয়ে দিন। Hearing এ দিয়ে দিন। এটা Wednesday দিয়ে দিন। List this matter heard, Mr. Tara. একটু উপরের দিকে দিয়ে দেবেন, একটু কথা বলে নেবেন আজকে, দেখিয়ে নেবো কিভাবে ম্যানেজ করছে।
কত টাকা আছে? কত টাকা?
চলুন নেক্সট কল করুন, দিদি কল করুন। কমিশন লিখে নিন। Can one of I don't know whether there is can be kept in first half of the second half we take up this or commercial matter at high matter. This could also take it up on second half only because hearing matters Wednesday I'll take it up on second half. In case you are in difficulty, we'll adjust, accommodate you on that day. We'll give it on the next day or maybe in the next week. Won't be a problem. It won't go to next Wednesday. It will be taken up on the next day, Thursday. If for any reason you are held up. Yes. None appears.
For taking instruction anyway.
None appears for the petitioner. Full stop. Mr. Chakraborty, learned advocate, is present for. लिखे नहीं. None appears. Oh, same.
All the dots are also debited. My lord, I beg to appear, my lord.
Yes, sir.
I beg to appear on behalf of the petitioners.
Yes, sir.
May I proceed?
Yes, please.
Lord, this is a writ application challenging the order of cancellation of an order of allotment of a plot in Salt Lake. Thereafter, I prayed for reconsideration of that order. That application was also refused. We have moved this honorable court and the matter is appearing for final hearing. Possibly there is no affidavit in opposition. I'm not challenging.
Who is appearing for the respondents?
I'm not sure, Lord, who is appearing.
And nobody is appearing, Mr. Mukherjee. There is no representation on behalf of these respondents.
And my lord, it's your lord's pleasure. Should I serve them a notice and then again we argue? I argue today.
Mr. Mukherjee, I think we should give him one opportunity because this is for the first time that it is being taken up and he's not there. So we can come back. I mean, we can meet next week upon putting him on notice.
Grateful.
It's recorded in the 7 July order that the state shall not use any operation. None appears for the respondents, although the petitioners are represented by Mr. Mukherjee, learned senior counsel. Full stop. The petitioners shall serve a notice on the respondents or the learned advocates representing the respondents, intimating them that the matter shall be taken up next on সামনে শুক্রবারের ডেট না সামনে শুক্রবার তো আবার ইয়ে থাকবে ডিভিশন বেঞ্চ থাকবে ডিভিশন বেঞ্চ আছে on February 27th. 27th February, Mr.
Good.
It will retain. Assigned hearing, it's the first matter. None appears for the petitioners. None appears for the petitioners. No accommodation is paid for ends of justice. Next. Call করুন দিদি কেউ না appear করলে এই অর্ডারটাই আবার করুন সেম অর্ডার চলুন কন্টেম্প গুলো কল করে দিন Page. So it's not absolute non-compliance. They have partly complied with it. You do one thing that then this is not willful and deliberate violation. You serve a copy on the that they will do. They may not be in a position to get for reconstruction. Also, they should have the information. Merely because none appears for the Where is that notice? Supplementary din देखिए. Yes. But then Mr. Bhattacharya contempt. Even then, for contempt, this is not a case. Contempt is willful, deliberate violation. They have substantial compliance is there. You come up against a writ against this order in a writ court. लिखे नहीं. The applicant alleges contempt Yes. Yes. Listening. This application alleges contempt. Next. फिर देना तो original site कौन सा? Original sites. Original site matter should be given now time. Okay.
My lord, with my lord's permission, may I mention one matter? My lord, this matter was mentioned by my petitioner yesterday, and the lordship was pleased to fix it on 10th of this month. Lordship, 9 and 10th, for my personal difficulty, I will be not in the city. I requested my learned friend, Prachi Real. So I requested them, they agreed to 13th. 12, 13, whichever. 13 is the Friday, so 12.
12, very good. 12 करोगे 12 तारीख को हाँ आइटम नंबर 35 तो 10 তারিখে ছিল এটা 12 তারিখে 10 তারিখে হ্যাঁ হ্যাঁ 12 তারিখে ও উপরে থাকবে আর কি লিস্টে
I'm the. Opere. Item number 1. Item number 1. Yes.
So we took out an application.
Yes.
I represent respondent number 6. We took out an application which is GA2. This is pursuant to the last order.
Last order.
This is the order dated
19th August.
And this is an application whereby we have prayed for being struck out from the area of parties. If we have arrived at a settlement, I have the draft with me.
Yes, what is this application for?
Well, this is where we have prayed that whether there has been a settlement between the petitioner and our authority, whereby the amount which was deducted by us, we will refund that amount. And pursuant to that refund by not, we may be struck off from the area of parties of the petition.
Your name may be struck off.
Yes, ma'am. Respond number 6.
Yes.
But as far as the writ petition is concerned, there is one more party who has not been represented till date. But it so my phrase is that one of the six names has been struck off, so we are expecting to settlement. For the writ petition concerned, that will get that pending as far as the other respondents are concerned.
What is the prayer in the writ petition?
Where you have the writ petition that for waiver of the detention charges, storage charges were collected. Actually, what has happened is that we reported certain products. Customs department wants to inspect those products. So it was not clear.
Whose name is sought to be struck off? 6.
That's 6.
7.
6, madam. We are the warehouse where the consignment was stored.
So your dues are being settled amongst each other.
Yes.
So you have, you don't have any grievance against him anymore. So his name will be struck off. And what is your principal grievance?
For waiver of the entire for the entire container storage charges from all the parties. The customs department also wrote a letter to the concerned party for waiver, but they have not accepted that. That is why we filed this petition saying for a waiver. So as far as there are 3 private parties, as far as respondent number 5 is concerned, settlement was entered in 2022.
That is the shipping line.
So respondent number 5's name is there. There is no application for deletion of 5's name.
5 minor has been struck off. Probably the amendment has not been carried out.
Yes, then the amendment ought to have been carried out. Five is struck off. 6 you want to be struck off.
Minor.
And 7 has not appeared as of. Yes, Mr. Banerjee, should you also be struck off? You'll be happier. Why don't you strike him off also? So better you keep on standing there, settled as dues. What is your answer on merits, Mr. Banerjee? What is they want waiver of something?
Only has a private arrangement between both the parties. If we can they are giving something, if they are not giving.
What was your prayer in the writ petition? Waiver of container storage or rent charges collected by respondent number 6 and 7.
6
Five
and
is
7.
not the shipping line, six is the warehouse.
So how 6, 7 is a private entity. Then
Seven.
how is a REIT maintainable against 6 and 7? In any case?
Create at the customs department. Go to the customs department, wrote a letter to respondent number 7. That he
Very well. If the customs has written a letter to respondent number 7 and respondent number 7 is disobeying the customs letter, how will the REIT court compel that to do? How is the REIT maintainable in any case? Answer that basic question first. That settlement I'll record, I'll dispose of the can. But what happens to the REIT petition? Why REIT is maintainable? Because yes, yes. Yes, Mr. Bhanjo.
They've also taken this part in our office, they have filed our opposition. The dispute between that shipping line and.
Yes, why should you take the shelter of a REIT court? What is the use? Because your prayer is also directed against respondent number 7. They have done something in gross violation of certain laws. For that, you will take up your remedy, whatever it is. There must be a remedy if they violate a law. That cannot be. You cannot have a writ against the private respondents.
private respondent is acting under the aegis of the customs department. But if they are not, the private respondent is not a private listed. They are authorized by the customs department.
They have a statutory duty to perform. Show me that duty once.
They're license back, but now the dispute between them. Whatever dispute between the private parties, what the customer will take.
And in case they act in violation of the statute, there is no other authority before whom you can approach. Show me.
Handling of customs area regulation.
Yes. Yes. Yes.
Seeking implementation of use case health. It applies to custom cargo service provider. It says that gives any person responsible for receipt, storage, delivery, dispatch, or otherwise handling of imported goods.
Now, if there is any violation of this regulation, what is the action provided for it? I mean, recourse. What recourse will you take?
If there is a violation, then the license of the concerned person may be granted. That is a report for the customs department to take. What we are seeking is that implementation of regulation 6L is that subject to any other law for the standing in court shall not charge any rent or demurrage on goods seized or detained or confiscated by the custom authority. But if you look at my
Very well. And disposing of the can, I am upgrading this matter because unnecessarily we are keeping this pending. This can be disposed of. लिखे नहीं. Can 2. Yes. It is our representative. Yes. Next. Highly Yes. Category unreserved. We are given one. Your category is the Voirago renting or reserved. Category from reserved is declared vacancy for nine of the candidates, no one counts to be. But the second internal candidate from the combined merit is the reserved category. This is to be built up by us. Now, by way of instances, I have discussed before this over that this has been done. Now, the same policy followed by the government of India. Page 15. Page 9. Page 9. The extensive study is not available. The vacancy for after the extensive study is 100%. Maybe build up and you have recruitment of candidates unreserved, non-expensive candidates. Yes. The
report of that. Paragraph 9.
Page 5. Yes.
However, such share of the petitioner cannot be accessible as the state evaluates the prevalent recruitment rule. The prevalent recruitment rule contains a notification of 2011 for the certificate. Now, there is a specifically provides that as no participants of existing percentage of reservation for HPS can notify category and category that we take the reserve point for each category A and category B shall be filled up by the exempted category candidates belonging to HPS category only. The state clause further provides that in case of non-availability of the exempted category candidates belonging to HCSC or OBC category A and category B, for any of the reserve points, the state vacancy shall be filled up by a non-exempted category candidate belonging to HCSC or OBC category. As the case, copy of the notification is titled particular. The above notification specifically provides for accommodating HC, SC or OBCA and category. Non-exempted candidates who vacancies of exempted category. No candidate valid exempted category only. The same notification does not get unreserved category at par. SC, SC or and does not provide for such accommodation for one person. Therefore, the share of the barred under causation of the now please come to now please come to the yes. Confident that about and come to the
Page 13.
So, upon being considered was whether percentage of reservation could be started on. And no participant of percentage of reservation for can be made. The reserve point for which both exempted category, OBC category A shall be filled up by the exempted category candidate belonging to HC, SC and OBC category A. In case of non-availability of exempted category candidate belonging to HC, SC or OBC category, for any of the reserve point, the same vacancy shall be filled up by a non-exempted category candidate belonging to HC, SC or OBC category and category. Now, let me come to the reserve point.
Yes.
Model management process of separate from the market from the art vacancy after consider the second vacancy, it will start with
Yes.
so what the administration purports to contain these 15 is participated only in respect of the vertically reserved candidates in the exempted category, not the unreserved category.
So from exempted to exempted, it is possible.
For then suppose there is no category candidate available in the vertically reserved category, meaning there was a last category. In those cases, this shifting is permitted by reason of paragraph 8 of that notification.
Yes.
Has no curtailment of existing percentage of reservation for SC, ST and OBC category that we made. The reserve points for SC, ST, BC,
Yes.
OBC category, SC and OBC category. And by the exempted category certificates belonging to SC, ST and OBC category A and B only. If there is no exempted category candidate available for the reserved, the article reserved category, then OBC category candidate or an SC category candidate or an SC category candidate.
Even unexempted from those categories only can be imported here, none else.
Reserved category.
Yes.
That's the content. But apropos this procedure, we have to what was the state government procedure, but as I said just now. Page 14 of my report.
Page 14. Yes.
In case unreserved exempted category candidates are not available, the vacancies in or unreserved exempted category candidates, the model 100.1 it is filled up by way of recruitment of candidates from unreserved non-exempted categories sponsored by so in 2011, the government was only considering reserved category candidates. In 2025, the government was considering unreserved category. So that particular provision of contained in paragraph 8 of the notification of 2011 will not apply in cases of unreserved category. Or in other words, there is no restriction apart from a plain exchange of the
Yes, Mr. Banerjee.
But I intend to answer on the next date.
Not today.
So Mr. Mojumdar has extensively argued.
Then when do we have? Next Friday? Next Friday? Heard.
It's on the same point, not same. There is already a notification to that of master state possible of everything. 12th of August 2025, four posts have now come up with. So we are looking at that to all the criteria. I have it and I'll keep it. So we will throw someone out to that they may not be necessary because he can do that to try and keep that. So it's service. The time is up. Not land will time us price to us. So I have the
Next matter, Mr. Joydeep Kaur is representing the administration.
register for
Mr. Ghosh, since Mr. Kaur is not there, we'll call the next matter next week. Yes. Intervening for what?
What is the appeal court will raise an order? That is the entitled to attend that court without any equities in there. Whether if lordship wants to add in terms of the appeal court lordship has to add. He may be added, but you no equity to it. That's the yes, your appeal, not my appeal, sir.
Very well. যেটা অর্ডার হলো তাকে দিলাম না 13th স্টেম অর্ডার তো কি করে করবেন, জয়দীপ কর সাহেব তো নেই। অ্যাডজাস্ট
Thank you.